Senator Padilla, Senator Cruz is willing to have you go next, even though he's next, and appreciate that. Thank you, Senator Padilla.
Thank you very much. He shares my pain, going back and forth to the Judiciary Committee, same day, same time. Thank you for the indulgence. Now, thank the three of you for your in-person testimony and our two witnesses that are participating virtually. Now, I agree that it's critical that we modernize and clarify the Electoral Account Act, and I'm grateful for the bipartisan group of senators that have come together to work on this issue. But I do have some questions for our witnesses on not just how we can best fix this law, but for a moment, I think it's also important for this committee and for this hearing to focus on two other related points about the Electoral Account Act reform. First, while the ambiguous text of the current Electoral Account Act left room for exploitation on January 6th, the text didn't exploit itself. People did. The former president did. Senators, members of Congress did. And an army of lawyers all had to give up on our democracy enough to give in to the big lie and use it to fuel a baseless challenge to the 2020 election. So while fixing the ECA is important, I think it's also important to remember why we need to do so in the first place. Because bad faith actors stand waiting in the wings to try again to exploit the text again for their own cynical ends. Second, fixing the ECA won't do anything to remedy the significant barriers to ballot access that far too many voters across the country continue to face. Fixing the ECA might make it harder to cheat in our elections. We hear that a lot from our colleagues, and we should absolutely do that. But I hope that we can soon find our way back to making it easier to vote as well. My first question is for Ms. Nelson. I know she's participating virtually, but let me ask Ms. Nelson to elaborate on the second point I just raised. Can you please expand on your testimony regarding the barriers to access that voters across the country will continue to face regardless of whether or not we reform the Electoral Account Act?
Yes, thank you, Senator Padilla, for that question. As I've said, both orally and in the written testimony, election sabotage does not occur only once a ballot is cast. It is also determined by who gets to cast a ballot in the first place and under what conditions. We know that voter discrimination and voter suppression is still rampant in our electoral system. We know that there have been hundreds of bills proposed and passed in states across the country that limit access to the ballot and that particularly have a disproportionate impact or were directly targeted at Black and Brown and other marginalized voters. What the Electoral Reform Act will do is to resolve many of the ambiguities concerning how votes are counted and what certifies an election and ascertainment, and to shore up so many ways that the exploitation of election results might occur. But it doesn't deal with the process of inputs, of who gets to vote and under what conditions. And that is why it must be complemented by legislation that protects the right to vote and restores the Voting Rights Act to its full capacity and creates uniform standards across the country for voters that cannot be manipulated or in any way discriminated against based on race or another protected characteristic.
Okay. Thank you so very much. My second question, it's more of a speed round for all the witnesses, is as follows. Now, the bipartisan group of senators that engaged in a serious effort to address some of the major vulnerabilities of the current ECA text, I appreciate their work. Now, the bill takes serious steps towards reducing, excuse me, the likelihood that the law can be exploited again, as it was. As it was on January 6th. But the committee,
You can take a second, Senator Padilla. We're fine. We'll give some extra time. We're all in a good mood here today.
but the committee has
There you go.
broader jurisdiction on elections. So I'd like to hear just briefly from each of you. We know what's in the bill. Is there anything else that you would suggest to this committee that be added to the bill to make it even better? We'll start with Mr. Gore and work our way down the table, then to the witnesses participating virtually.
Thank you, Senator. I do believe that some of the technical corrections that have been suggested to the bill by Professor Mueller and others are appropriate. We had a back and forth earlier about the time period for bringing challenges under the Reform Act and this question of whether 6 days is sufficient. I do believe that the 5-day notice provision in 28 U.S.C. 2284 for actions brought before a 3-judge court involving a state officer or a state official should be waived for these kinds of cases, just to ensure that there's as much time as possible to resolve any federal constitutional or statutory claims.
Ambassador?
Thank you, Senator. I think extraordinary and catastrophic should be defined. I think the timing should be extended. We still had state litigation going in 2020 during after the so-called state harbor and after the Electoral College met. I think that lawfully certified and regularly given needs to be defined better to prevent mischief here in Congress. And in my testimony, I've laid out some procedural specifications that I think is important to put in. If you call those clarifications and technical corrections, I'm all for them. And I do appreciate the huge bipartisan effort.
Mr. Mueller?
With Senator Warner's endorsement, I think I'll rest on the 4 recommendations I put in my written testimony.
Thank you very much. Mr. Bauer?
I do not think there is a gaping hole in the statute. I do think that there are technical corrections of the kind that I understand Professor Mueller has advanced, clarifications that could well be in order and could help to answer questions and secure bipartisan passage. I would contrast that with any glaring weakness in the design. I don't think there is any glaring weakness in the design, but those technical corrections and clarifications, it seems to me, are appropriately considered.
Thank you. And Ms. Nelson?
Yes, I shared some principles that we hope will guide this committee's consideration of any tweaks to the ECRA, but I will say some more specific, I'll state some more specific recommendations. We think that with respect to the timing, while we are not promoting a particular time period for expansion, that the 6 days for litigation is, they're rather tight if we consider what needs to happen within that time period. So we urge the committee to think about some expansion of time for litigation and to ensure that there aren't any unintended consequences. We've also raised some issues concerning the assignment of judges for the judicial process to ensure that there is no actual and more importantly, no appearance of bias that may undermine public confidence in the process. We also believe that the right to a mandatory appeal to the Supreme Court is something that this panel should consider and think about, ensuring the Supreme Court's review of these all-important issues when they arise through the federal judicial process outlined in the ECRA, and then also to make it very clear that the process in the ECRA does not supplant or supersede any state or federal court avenues. And I think that we've articulated that several times in this discussion today, but we want to reiterate that point because it's very important that voters still have an opportunity to vindicate their rights under state and federal law outside of that process.
Thank you. Thank you all. Thank you, Madam Chair.
Okay, thank you. Good question, Senator Padilla.